Hello and welcome to our podcast. I am Abby, an associate in our commercial disputes team, and I'm joined by Luke, an associate in our corporate team.
Hi everyone, so today we are going to be talking about collective investment schemes, commonly referred to as CISs for short. We presented on this recently at our firm's Financial Services seminar, but for all those who couldn't make it or would like a recap, we thought we'd also pull together a podcast.
Perfect. So we are going to whiz through what collective investment schemes actually are, how they are regulated, how the FCA is dealing with them, and then we'll also look at what protections and claims might be available to investors who have been missold collective investment schemes.
So turning first to what they are, a CIS is defined under Section 235 of the Financial Services and Markets Act 2000, which we'll call FSMA for short. A CIS is any arrangement relating to property of any description, and this is very wide. Property here can include money, shares, real estate, or virtually any other asset. Examples could include horses, which is common in the context of betting syndicates, as well as wine collections and land. The arrangement must enable participants to participate in or receive profits or income arising from the property. Importantly, and central to the definition, the arrangements must be such that participants do not have day-to-day control over the management of the property. And finally, the arrangement must involve either or both. Firstly, the pooling of contributions or profits or income, or secondly, the property being managed as a whole by or on behalf of the operator of the scheme.
And the courts have interpreted this definition pretty expansively in FCA and Asset Land, which was a Supreme Court case. Now, the judgment was back in 2016, but it's still one of the leading authorities. The FCA brought this prosecution against Asset Land for illegally operating and promoting an unregulated CIS. Investors each had individual plots, but the land in practice was managed as a single project by a central manager, meaning that the investors had no actual control over their investment. So this met the definition that Luke just outlined, and it was deemed to be a CIS. The Supreme Court confirmed in this case that it's about the substance, not the form. So what that means is that it's the real-world operation of the scheme that the courts will focus on, even if the legal documents suggest that it might not be a CIS.
Exactly. The definition is deliberately wide to capture a broad range of investment arrangements. So, turning to how they are regulated, under Section 19 of FSMA, which is commonly referred to as the general prohibition, no person may carry on a regulated activity in the United Kingdom or purport to do so unless he is an authorised person or an exempt person. Operating a CIS is a regulated activity that requires FCA authorisation.
And it's important to note that if you don't have authorisation, this could result in a criminal offence, fines, imprisonment of officers, and the inability to enforce contracts with investors. So it is a really serious matter.
Definitely, this is one of the strictest parts of the UK's regulatory perimeter. Now, there are two categories of CIS, regulated and unregulated. Regulated schemes such as authorised unit trusts and open-ended investment companies, which are widely marketable to the general public, whereas unregulated schemes are considered much higher risk and cannot be marketed to the general public. Alternative investment funds often fall within the definition of unregulated schemes, and in most cases, they do need to be authorised. The key difference, as the name suggests, is whether the FCA regulates the scheme. And Abby, I think you'll be touching on this in more detail later, but fundamentally regulated CISs are subject to stricter rules on asset types and borrowing. Unregulated CISs may invest in riskier assets or use riskier investment strategies. But whilst the FCA will not regulate the running of an unregulated CIS, it will still regulate their promotion, as it will regulate the promotion of a regulated CIS.
So even if you don't operate or manage a CIS, are you still subject to FCA regulation even if you're only promoting a CIS?
Absolutely, as you will be subject to financial promotion restrictions. So going back to FSMA again, Section 21 provides that no one may communicate an invitation or inducement to engage in investment activity unless they are FCA authorised, the communication is approved by an authorised firm, or an exemption applies. Exemptions are set out in the Financial Promotion Order 2025, which we'll call the FPO for short. These include high net worth investors, certified sophisticated investors, and self-certified sophisticated investors. Each category requires specific signed investor statements and mandatory risk warnings in very prescriptive formats.
So just to summarise that, you can promote an FCA authorised scheme, for example, a regulated CIS, to anyone, hence why we referred to them earlier as being widely marketable. But you can only promote unregulated CIS to those discrete categories of investors listed in that exemption list, such as certified sophisticated investors.
Spot on.
So flipping the narrative now, and we wanted to touch on the protections that are afforded to investors if they invest in the CIS, and it all goes horribly, horribly wrong. For example, because they were missold the scheme in the first place. Now, investors will primarily be concerned with receiving financial compensation for their losses. So we'll usually look to the Financial Ombudsman or Financial Services Compensation Scheme, which I'll just refer to as the compensation scheme for ease. Now, you would approach the Ombudsman if the firm or individual you were in dispute with was still active and trading, and you would apply under the compensation scheme if they're in default or failed. So, for example, if they've entered into insolvency. So it's one or the other. Now, if you're dealing with a regulated CIS, you are protected under the compensation scheme for losses directly related to your investment, up to the usual investor protection limit, which was very recently in December 2025 increased up to £120,000. You can also complain to the Ombudsman. Now, as a reminder, you should always try and resolve it directly with the firm first before escalating to an Ombudsman complaint. You can then include copies of your correspondence with the firm in your complaint to the Ombudsman.
However, with an unregulated CIS, the compensation scheme will not cover investment losses. This is because the unregulated CIS is an unregulated product. This lack of investment protection is part of why unregulated CISs are deemed to be high risk.
Exactly. Now, the only circumstances in which regulatory protection might apply where you're dealing with an unregulated CIS is where an FCA-regulated firm provided a service and that service was a regulated activity. So in this context, that might, for example, be where a regulated firm advised you to invest in an unregulated CIS. The advice itself is a regulated activity, and so you might be entitled to compensation if that advice was inaccurate or misleading. Or if you've been promoted or sold a CIS which is not suitable for you, or without having explained the risks to you first. And that reflects what Luke mentioned earlier, that the FCA does not regulate the running of an unregulated CIS, but it will still regulate its promotion, and that includes advice relating to it.
If you feel you were missold a CIS, or you've suffered investment losses you think are covered by the regulatory protection we've just outlined, the first port of call is to check the FSCS website to see if the firm in question is listed as being in default or a failed firm. If it is, proceed with submitting a compensation scheme. If not, and the firm is still trading, try and resolve it with them first, and then, if not satisfied, escalate by complaining to the Ombudsman.
Do you mind just touching on what the regulator will be looking for, particularly if you're dealing with an unregulated CIS?
Of course, so one of the first things they will consider is whether the advice was suitable based on the investor's risk profile. As we touched on earlier, unregulated schemes are high risk and should not be promoted to the public or retail customers. They will also consider whether the advisor gave full and clear advice about the unregulated scheme, in particular warnings about it being high risk and not being covered by the FSCS for investment losses. They will also consider whether the advisor conducted appropriate due diligence on the unregulated scheme before recommending it. The focus is therefore on the advice and promotion quality, the regulated activity, rather than the unregulated scheme itself, the unregulated product.
Brilliant, thank you. So finally, we now want to look at what action the FCA is taking. And the first example I want to talk about is the case of Harlequin property. So this was an unregulated CIS involving Caribbean resort developments. Thousands of UK investors were advised by FCA-regulated firms to invest, often via SIPPs. And just to give an idea of scale, approximately £400 million was invested in the projects in total. Now, the scheme collapsed, leaving investors with significant losses. One of the FCA-regulated firms which were advising people to invest in this scheme was Tailor-Made Independent Limited, TMI for short. Now, despite the acronym of its name, it was found to have given far too little information to investors. exposing customers to the risky investment without first considering whether it would actually meet their needs. So as a result of this, the FCA banned TMI's former director from senior positions in financial services and also fined him just over 40 grand. And the FSCS, who had gotten involved because TMI had dissolved, investigated claims by investors and continues today to pursue recoveries. So far, it has compensated over 2,700 investors who had collectively invested more than 125 million in Harlequin.
And didn't the Serious Fraud Office also get involved?
Yeah, it did. And as a result of its investigations, Harlequin's chairman was found guilty of 2 counts of fraud by abuse of position and was sentenced to 12 years in jail, which gives us a sense of how serious these matters are taken.
Absolutely. So, I think the other case that pops into mind is Argento Wealth Limited, which I'll touch on now. So, Argento promoted and operated an unregulated scheme in overseas properties. It took around £2.8 million from investors, and as we touched upon earlier, operating a CIS is a regulated activity and requires FCA authorisation. Argento, it turns out, was not authorised and so breached Section 19 of FUSMA, which is a criminal offence. Argento also promoted the unregulated scheme to retail investors, despite the FCA rules restricting unregulated CIS promotions to sophisticated or high net worth individuals. The promotions were misleading, failing to disclose the high risk and lack of compensation scheme protection. Unlike TMI in the Harlequin property case, Argento was not in default. It was still trading, in fact. So the FCA issued civil proceedings against Argento and its sole director to recover investor funds. The parties have in fact recently settled, with Argento agreeing to pay the FCA £1.6 million. This was approved by the court in a consent order.
It's really helpful to see the comparison between the action taken if the company at fault is still trading or if it's insolvent. And I think it's also reassuring for investors that financial remedies can be available in either circumstance.
Also, the consequences for those running these schemes, if they do so illegally and in breach of regulation.
For sure. And it's not just litigation brought by the FCA that they need to be concerned about. The investors themselves might also have civil claims that they're able to bring personally. So, for example, you might have a breach of contract claim if the firm acted outside the scope of the agreed investment mandate or otherwise breached the disclosure or suitability requirements in your contract. If an advisor failed to exercise reasonable skill and care when advising you to invest, you might want to look at bringing a negligence claim. Or finally, if a false or misleading statement was made about the CIS, which you relied upon when deciding to invest, a misrepresentation claim might be the route for you. So don't just look at regulatory protection. Make sure you consider other civil claims that might be available to you as well.
So to end, Abby, what are your key takeaways, would you say?
I think from an investor's perspective, the importance of taking advice from an FCA-regulated entity, that probably sounds like common sense rather than necessarily a top tip. But as we've talked about, it could mean that you're protected under the compensation scheme or could have avenues such as a negligence claim if you invest in a CIS on their poor or misinformed advice. Whereas if you just plough straight ahead and invest in an unregulated CIS without taking advice, your recourse if it all goes wrong is rather minimal. And when you do seek that advice, just make sure you get all the details. Ask whether the product is regulated, what the risk profile is, ask if you are covered by the FS compensation scheme, does the product qualify as a CIS or might it, and what due diligence did your advisor conduct before giving you all of that advice. So don't be afraid to ask those questions. Ultimately, it's your money that's being invested. What about you, Luke? What's your key takeaway?
Well, I think for me it's probably the breadth of the CIS definition and really how many schemes are unintentionally caught by it. So, for example, any property can form the basis of a CIS. Horses, wine, carts, art, you name it. And with the courts interpreting the SIS definition so broadly, it's certainly worth obtaining legal advice so that we can conduct that early CIS analysis for you. If you want to avoid CIS status, we can look at how to avoid pooling or passivity on the part of the investors. But if you are going to run a CIS, or a scheme likely to be deemed to be a CIS, do plan to get FCA authorisation. We've talked about the consequences of not doing so, and it's not worth the risk.
Thank you, Luke. That has been really helpful. And thank you to everyone who has been listening. That was our whistle-stop tour through collective investment schemes, and really it only touches the surface of the topic. If you do need any legal advice on these matters from whichever perspective, our firm is available to help. So please do get in touch.
Thanks all.